Senate will come to order. Will the clerk please call the roll?
Senators Baisley, Bridges, Senator Bridges.
Absent.
Thank you. Buckner, Coleman. Thank you.
Order in the Senate.
Cutter,
Please mark Senator Bridges as present.
Danielson, Exum, Fields, Gardner, Janal, Senator Janal. Thank you. Gonzalez, Hanson, Senator Hanson, Henriksen. Thank you. Jaquez Lewis. Senator Jaquez Lewis. Kirkmeyer. Kolker. Liston. Senator Liston. Senator Liston. Lundin. Marchman. Michelson Janae. Mullica. Pelton B. Pelton R. Priola. Rich. Roberts. Rodriguez. Simpson. Smallwood. Sullivan. Van Winkle. Will.
Excused.
Winter. Thank you.
I don't know.
Zenzinger. Mr. President.
Here.
Thank you.
The morning roll call is 34 present, 0 absent, 1 excused. We do have a quorum. Senator Rich, would you please lead us in the pledge?
Please stand and join me in the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Approval of the journal, Senator Roberts.
Thank you, Mr. President. I move that the Senate Journal of March 5th, 2024 be approved as corrected by the Secretary.
You have heard the motion. All those in favor say aye. Aye. Opposed, no? The ayes have it, and that motion is adopted. Members, when I think about my days in the Senate, my most fond memories are those late nights debating hamburgers in voter service center locations. And that's thanks to my good friend Jack Tate, who's back here in the state Senate. The strangest yet most fun debates I've had in these 8 years were with you, Jack. Thank you for being back here. Senate Services.
March 6, 2024, correctly printed Senate Bills 174 and 175, correctly reengrossed Senate Bills 108, 132, 145, and 155, correctly enrolled Senate Joint Resolution 8.
Committee reports.
March 5th, 2024, the Committee on Finance has had under consideration and has had a hearing on the following appointments and recommends that the appointments be placed on the consent calendar and confirmed. Members of the Board of Assessment Appeals effective July 1, 2023 for a term expiring June 30, 2024. Monty Mullins of Alamosa, Colorado, reappointed. John DeRungs of Denver, Colorado, reappointed. Claudia Crane of Crestone, Colorado, reappointed. Diane DeVries of Wheat Ridge, Colorado, reappointed. Jessica Ketchum of Pagosa Springs, Colorado, reappointed, effective July 1, 2023 for a term expiring June 30, 2027. Sandra Mercier of Westminster, Colorado, reappointed. Member of the Board of Assessment Appeals for term expiring June 30, 2024, Jeb Marsh of Dillon, Colorado, appointed. Members of the Advisory Committee on Governmental Accounting for terms expiring May 18, 2027, Carrie Bartow of Colorado Springs, Colorado, to serve as a representative of Special Service Districts, reappointed. Brenda Ritchie of Boulder, Colorado, to serve as a representative of City and County Governments, reappointed. Executive Director of the Department of Revenue for term expiring at the pleasure of the Governor, Heidi Humphreys of Evergreen, Colorado, appointed. After consideration of the merits, the committee recommends the following. Senate Bill 120 be amended as follows, and is so amended be referred to the Committee on Appropriations with favorable recommendation. House Bill 1119 be referred to the Committee of the Whole with favorable recommendation and with a recommendation to be placed on the consent calendar. Senate Bill 76 be amended as follows, and is so amended be referred to the Committee on Appropriations with favorable recommendation. March 5th, 2024, Committee on Business, Labor, and Technology. After consideration of the merits, the committee recommends the following. Senate Bill 149 be amended as follows, and is so amended be referred to the Committee on Appropriations with favorable recommendation.
Introduction of bills.
House Bill 1039 by Representatives Vigil and Titone and Senators Winter and Marchman concerning non-legal name changes for students in schools.
Education.
House Bill 1057 by House Bill 1057 by Representatives Woodrow and Mabry and Senators Gonzalez and Hinrichsen concerning prohibiting the use of an algorithmic device by a landlord for the purpose of determining the amount of rent to charge a residential tenant and in connection therewith declaring that such use is an unfair or deceptive trade practice under the Colorado Consumer Protection Act.
Local government housing.
House Bill 1082 by Representatives Taggart and Mabry and Senators Rich and Coleman concerning the designation of state institutions of higher education as first-generation serving institutions.
Education.
House Bill 1087 by Representatives McCormick and Armagost and Senators Kirkmeyer and Marchman concerning the creation of additional pathway for educators to gain an endorsement for special education instruction.
Education.
House Bill 1277 by Representative Doherty and Holtorf and Senator Gonzalez concerning the continuation of the Youth Restraint and Seclusion Working Group and in connection therewith implementing the recommendation in the 2023 Sunset Report by the Department of Regulatory Agencies.
Health and Human Services.
House Bill 1291 by Representatives English and Joseph and Senators Roberts and Gardner concerning a licensed legal professional's authority to represent individuals in certain domestic relations matters.
Judiciary. General orders, second reading of bills. Senator Marchman.
Thank you, Mr. President. I move the Senate resolve itself into the Committee of the Whole for the consideration of general orders, second reading of bills.
You have heard the motion. All those in favor say aye. Opposed, no. The ayes have it. The motion is adopted. The Senate will resolve itself in the Committee of the Whole for the consideration of the general orders, second reading of bills, and Senator Marchman will take the chair.
The committee will come to order, and the court rule is relaxed. Will the clerk please read the title to SB 94?
Senate Bill 94 by Senators Gonzalez and Exum and Representatives Lindsay and Froelich concerning safe housing for residential tenants and in connection therewith establishing and clarifying procedures regarding a tenant's claim of breach of the warranty of habitability.
Majority Leader Rodriguez.
Thank you, Madam Chair. I move that Senate Bill 94 lay over for one day till March 7th, Thursday.
The motion is to lay over SB 94 to March 7th. All those in favor say aye. Those opposed, no. The ayes have it. SB 94 will lay over until tomorrow, 3/7. Will the clerk please read the title to HB 24-1067?
House Bill 1067 by Representative Ortiz and Bradley and Senator Winter concerning ballot access for candidates with disabilities.
Senator Winter.
Thank you, Madam Chair. I move for second reading and passage of Senate Bill 1067.
Senator Liston.
Thank you, Madam Chair. Members, I sit on the State Veterans and Military Affairs Committee where we heard this bill, and I was intrigued by the purpose of what Senator Wenders is attempting to do to give the disabled people out there a little more of an opportunity to engage in the political process as a candidate. And we all know, just as regular people, what it's like to be a candidate, and particularly for those people who, there's two ways to access the ballot, as we all know. You can go through the caucus process, which is somewhat convoluted and tough for a lot of people. There's a lot of locations to go to and a lot of delegates and trying to figure that out. Or the other way that you can access the ballot is by the petition process. And for those of us on both sides of the aisle that have gone through the petition process, myself included, quite frankly, it's a lot of work. It's trying to get out there and seeing the various people to sign your petition. Right now, under current law, you have 60 days, and depending on the office that you're running for, you've got to get a minimum of 1,000 to 1,500 or more signatures, and that's the bare minimum. You can't just, for a legislative seat, you can't just turn in 1,001 signatures. It's a lot of work, and particularly for someone who might be disabled, to try and get around and see people. So I thought, as a way to help candidates who might be disabled, is why not just give them a little extra time? And so with that, members, I have an amendment in mind.
There is an amendment on the desk. Will the clerk please read L006?
Amendment L006, amendment Gross Bill, page 3, line 4,
Senator
strike.
Liston.
Thank you, Madam Chair. Members, what this amendment, first of all, I move L006.
Very good. To the amendment, Senator
Yeah,
Liston.
what this amendment does, members, is that instead of limiting the petition process to 60 days, it will allow for people to start gathering signatures on the first business day in January, and for all candidates. So in essence, we're giving the candidates about an extra 2 weeks, which will help everybody. So I think it's a good, reasonable amendment that will help everybody, and I would respectfully ask for an aye vote on L006.
Senator Winter.
Thank you, Madam Chair, and thank you to the good senator from El Paso County. I think this is an incredibly important amendment. It is important that folks with disabilities have access to the ballot both through the caucus process and through the petition process. And this makes it more accessible through the petition process. I personally have pulmonary hypertension, which is often called the invisible disability. It makes it harder for me to breathe. I have 70% of the lung capacity that all of you have. So as you go out collecting petition signatures, I have 70% of that capacity. And so ensuring that I could take on the petition role and also meet my medical requirements, this is an incredible, important amendment. And I appreciate my senator from El Paso County coming up with this amendment, and also for agreeing to come on to the bill as a co-prime sponsor once we pass this, and I encourage a yes vote.
Is there any further discussion? The motion is the adoption of Amendment L006. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it, and the amendment is adopted. To the bill. Senator Winter.
Thank you, Madam Chair. For democracy to work in its best capacity, we need all backgrounds represented because we can find our best solutions when we have a diversity of views coming to the table, and having access to the ballot is a fundamental reason to give people with disabilities a seat at the table. This bill moves this forward immensely, and I encourage a yes vote.
Senator Liston.
Thank you, Madam Chair. Members, I'm proud to help the good senator from Broomfield. Yeah, the good senator from Broomfield, I'm sorry. And I think this amendment will make a decent bill even better. And I would urge an aye vote for House Bill 1067 that will help all people access the ballot, and especially through the petition process. Thank you.
Senator Gardner.
Thank you, Madam Chair. Well, as I said yesterday, this bill addresses an important issue, and it's one we ought to consider. But let me say this now, it ought not be ill-considered, and this bill, even now, is ill-considered. A not uncommon malady for legislation in the Colorado General Assembly, that it is ill-considered. Ill-considered by not a lot of thought, ill-considered by not a lot of time to consider. I didn't jump in here to object to the amendment. It is what it is, but it doesn't really address the issue of one with a disability having some greater amount of time to collect their signatures. It just lengthens the time for everybody to collect their signatures, which is not particularly a bad thing. Right now, what really people get is about 60 days. This is going to create the ability, I think, I've got a copy. I think the senator, the other several senators from El Paso County, but I have a copy of the amendment. It's not that. It says everybody has the 75th day after the first business day in January, whichever is later. And I haven't calculated that on the calendar because right now it's close of business on the third Tuesday of March. So it doesn't, it gives everybody more time. Okay. Doesn't really address the increased difficulty for people with disabilities vis-a-vis those without. And I do appreciate more than anyone can imagine the striking of this line, a couple of 3 lines here that says the petition process by which candidates may access the ballot is not a means of ballot access that is accessible to persons with disabilities, et cetera. I appreciate that because that was an invitation to an Equal Protection and Americans with Disabilities Act lawsuit. Ill-considered, I said. So maybe we considered a little bit in this process. Now, let's go down to the caucus and assembly process. I think there's like 400 caucus meetings in El Paso County. I assume places like Denver have similar numbers. And each and every one of them will have to create a process for having participation by Zoom or Teams or Google Meet or whatever other platform you have. Okay. Now, you say, but that's not what the bill says, Senator. It doesn't say each and every one does. It says it is in a political party's discretion. Now, there are oxymorons in the law, and political party and discretion is an oxymoron. At least in my experience of some 35 years as a party officer and other things, political party discretion is more like political parties' abuse of discretion in recent times. But they will have discretion to determine which video conferencing platform will be used. Okay, well, there are 3, maybe there are others. There are 3 I encounter on a daily basis and use them in business and in other things. So long as the platform is accessible to persons with disabilities. Well, we've recently learned that access to persons with various disabilities can be more problematic. Ask someone on the executive committee or ledge council about dealing with that of our own website. And then it says, each political party shall establish policies regarding the procedure and timeline for a person to request to participate in a precinct caucus or a party assembly with the use of a video conferencing platform. Well, an invitation to all sorts of lawsuits at that point. What if a person with a disability on a Monday morning before a Tuesday caucus, or as the case in El Paso County, a Wednesday morning, right now, for caucuses tomorrow evening, says, oh, as often happens with citizens, my caucus is tomorrow night. I would like to participate. What if that person wakes up on Thursday morning and says, my caucus is tonight? I mean, because people do this all the time. People with disabilities, people without. And they wake up and they say, well, I want to participate. I'd like to participate remotely. Oh, the party in its discretion, quote, quote, said that you needed to request that 10 days ago. You can't participate. Now, let me hypothecate a little further. That person comes to my office and says, my office, my Simple Country Law office, and my life beyond legislative service, and says, Mr. Gardner, I want to participate in my caucus tonight, but the party says if I didn't ask 10 days ago, I can't do it. And I believe that's an unreasonable time period under the terms, because it's a First Amendment right to participate, and I shouldn't have to give 10 days notice to, or even 3 days notice. I should be able to exercise my First Amendment right by showing up at the meeting at 7 p.m. Or because the Colorado General Assembly says I can do so remotely, I should be able to do so just a few minutes before 7 p.m. Will you file suit for me? Well, maybe I will, because attorney's fees and costs under the Americans with Disabilities Act is a pretty attractive thing. Now, I want to be clear. I think there are ways to deal with this. I think there are ways to work through this. I think there are ways to set up some parameters for this. But I don't know. I mean, any sort of a time period, I mean, would it be okay for a political party to say you cannot participate in your caucus, which is a state-sanctioned event, by the way, 150-year mistake, I believe, of mixing party structure and process with government, but nevertheless, it's where we are today. Would it be okay for a political party to say to those without disabilities, you cannot participate in your caucus unless you sign up 3 days in advance? You can't just show up at 7 p.m. and walk through the door and sign in. You have to give notice that you're going to participate in your caucus. Would I take that case? Yes, I would take that case under a Civil Rights Act lawsuit, because I think when a person shows up at 7 p.m. at the designated caucus location as a registered member of whichever party that caucus is, they, without having given notice in advance, have a First Amendment right to participate. In the same way that you don't have to give advance notice that you're going to vote next week. You didn't have to give advance notice that you were going to vote if you wanted to go vote in person yesterday. You could have awakened in the morning or suddenly said after dinner, assuming you ate early enough, last night, I want to vote in the presidential primary. I'm going to run down there and get a ballot and do it. I don't have to give anybody any notice. You say, well, but this is different. Well, that is the problem, folks. Now, I suppose there's a counter-argument that, well, we're going to accommodate those with disabilities, so they have to give, that doesn't come out very well as I start to make that argument. We're going to accommodate people with disabilities and allow them to participate, but they have to give notice of their participation, a kind of notice for their participation that people without disabilities don't have to give. So say I was party counsel. I have been one. And I was asked to advise the party about what they should do with this. I would say you need to, for all of your 400 locations, you need to set up a video meeting, which you must ensure that that video platform is fully accessible by anyone with a whole variety of disabilities that we could imagine. I mean, maybe someone is just, I don't want to use the word just, but maybe they're fully able to see and hear. They are confined to their home for some reason. That's probably pretty easy to make it accessible because they just sign on to the video conferencing app and there they go. But what if they are blind? What if they're visually impaired so that they can't see the screen? Well, you're going to have to deal with that. And what if they're hearing impaired? You're going to have to have a app that takes care of that. Well, I think the apps generally do, but you're going to have to make sure that all of your volunteer precinct committee people who are not government officials, who may just have picked up their caucus packet 2 days before, got recruited to run one of their 400 caucuses, are conversant with all of this. It might be an argument for why the caucus and assembly system has seen its time and come and gone, but that's for another day. That might be if one were not giving due consideration, or one giving ill consideration might conclude that the caucus and assembly system discriminates in the way that it must necessarily be implemented, necessarily discriminates against those with disabilities. That's an interesting notion. And if we actually considered this problem and gave it due consideration and thought, that might be where we end up. But this bill creates way more problem than it solves. It doesn't answer the issue very well. It relies on something that I find almost laughable: political party discretion. When you see that, it's not, they will say, well, that means our absolute discretion, and I would say, no, that means your reasonable discretion. We don't say which in the bill. That's kind of a drafting problem. Let me say this one more time. I support reasonable accommodations for those with disabilities to participate in the caucus assembly process, and we ought to do that. I mean, if that's the way we're going to put people on the ballot in Colorado, and we have for long before my time, then we need to think about that. And, we may have to start providing financial support to political parties. Oh my goodness, maybe we don't want to do that. We have to think about this. That's my concern about this bill. Not that it's ill-intentioned in any way. I wouldn't question anybody's motive in any way, but I just want to make clear, not that it's ill-intentioned in any way, not that it doesn't deal with a very serious issue and problem about which we should have a discussion and perhaps an ongoing discussion, but because it creates more legal problems than it solves. It probably hurts more people ultimately than it helps. It creates confusion in the electoral process. And by the way, are you in favor of anything that creates more confusion in the electoral process? Seems like we've had a little problem with that in the past several years. Whether we should have or shouldn't have, beside the point. Beside the point. So I appreciate the efforts. I appreciate the effort to amend the bill. It solves a bit of the problem. It leaves huge gaping holes in dealing with the problem. And therefore, I will be a no vote. And I would encourage all of you to, instead of give cursory consideration or ill consideration to this bill. Give it greater consideration. And if you really must, send it, you know, if you feel like we've got to deal with it this year, I mean, we're not going to deal with caucuses in the Assembly this session, frankly. They're already on their way. Send it back to State Affairs or wherever, and let's get testimony on how to truly deal with it. I'll be a no vote.
Senator Baisley.
Thank you, Madam Chair. I was the sole no vote in committee on this bill for the reason that it violates the principle of government overreach. Just as the good senator from Colorado Springs was explaining, there are unintended consequences, and unintended consequences to something that's a reasonable, good idea that can be implemented via common sense and with a big heart for folks that need a little extra help and accommodation. Those are fine, and then you can adjust along the way. But when you make use of government to implement an idea, then that is the use of force, and it becomes very stringent, and bad ideas are implemented much more forcefully and permanently. So let me walk you through the glaring problem I see with this bill. I'm going to read just the paragraph to it, maybe a couple of times. Notwithstanding any provision to the contrary, within 6 months of the effective date of this section, any person, emphasize that, any person upon request must be able to participate in a precinct caucus or a party assembly with the use of a video conferencing platform. The political party holding the caucus or assembly must allow participation with the use of a video conferencing platform without requiring or requesting an explanation of the need for the use of the video conferencing platform. So, if a Republican, if I decide that I want to address the caucus of the Democrat Party and talk to their assembly, I simply make a request to the Democrat Party and say, I wish to address your assembly, and they must allow me to participate and provide me with the video teleconferencing platform to address the Democrat Party. Not only to their assembly, but on caucus night, which is coming up here this week, to every caucus assembly. Now, if you're experienced with the caucus night, then you'll know, or caucus day. I guess we on occasion will do that on a Saturday early, but these things take place throughout the state in many, many schools typically, and in many classrooms within those schools. So imagine the requirement to set up video teleconferencing for all of those many, it's got to be in the hundreds, the number of caucus gatherings that must accommodate those addresses. So a Democrat could require the addressing, not just a Democrat, anybody, because it says any person from around the world could require that their voice be heard no matter what message that they want to deliver to Republicans, to Democrats, and say, you need to start behaving in a particular way because that's my belief system. I've made my request, so you must give me access. You must provide video teleconferencing into your caucus or your state assembly. This is really poorly written because while it does give the party some discretion, it doesn't give the party discretion to say, hey, that person who's asking for access and for us to deliver that message right into our caucus or right into our assembly is someone of our party, someone who is a candidate, someone who makes sense. No, the only discretion it gives them is which video conferencing platform that they're going to use in order to deliver that message that may be completely inappropriate for a caucus or an assembly. So this is a glaring mistake in the writing and the drafting of this bill. So it's my recommendation to the sponsors of this bill that they at least consider that, because that could go really wrong for both major parties. And I'd recommend that either you follow the recommendation of the good senator from Colorado Springs, send it back to committee for reconsideration, or at least consider a third reading amendment to correct these things. Otherwise, chaos will ensue, and it will not just ensue because there's a good idea being implemented in a bad way, but it's a good idea being implemented by the force of government in a bad way. So I therefore urge you follow my lead from committee and vote no on this bill. Thank you.
Senator Danielson.
Thank you, Madam Chair. I rise in support of this measure. I think that we need to do everything we can to make this state more accessible for people with disabilities across the board. When it comes to candidates and the caucuses and getting on the ballot, we need to do that as well. It's a no-brainer for me. Caucuses are the only truly, really accessible way for candidates to get on the ballot, and the bill will require those caucuses to be accessible. You can't just call the night ahead and ask for certain accommodations. I think we need to just refocus on the facts and what's in the bill. This is a way to make the caucus process more accessible for people with disabilities. I am firmly in favor, and I applaud the sponsors for bringing it forward. Thank you very much.
Minority Leader Lundin.
Thank you very much, Madam Chair. I rise not in opposition to the concept, the idea, the end point and goal. I completely support that, but I rise in opposition to this bill because the challenges in operationalizing this are manifest and manifold. They are very clear and they are very many. A little bit later today here, in fact, probably in fairly short order after we finish debate on this particular piece of policy, House Bill 1067, we will take up a resolution, a Senate Joint Resolution 013, which is concerning honoring disability rights in Colorado. I expect that that resolution will be unanimous in its support and will call down upon the administration of this chamber that all members in the current roll call co-sponsor that, because we all do believe that, in fact, increasing accessibility is the goal, is the endpoint, is what we must strive towards. However, it is clear in my reading and understanding of, excuse me, House Bill 1067 that as we try to operationalize this, it's going to break, and it's going to break time and time again due to a number of challenges in the actual application of what this law would call for. I will not spend time repeating the arguments that have been made by colleagues in defining the operationalization challenges that exist, but I do want to point a few things out in the bill that are meaningful. Before I get into that, on page 3, line 18, and I will just call this out, the drafters can figure out whether, in fact, the word in this line is exactly what they want or whether they would reconsider. It is my understanding that we have moved away from the anachronistic shall when commanding, demanding, prescribing, and using must is a word instead on page 3, line 18. The drafters may want to take a look at that and see if they want to technically clean that up. It calls shall out as the word it's used here. It is my understanding must might be preferred. So that's just a footnote as we're moving through this debate. Objection number one in this highly unoperationalizable law is found on page 4, lines 13 through 18, which is a private right of action. It says, we're going to give you a really challenging parties of Colorado, Republican, Democrat, minor parties, if you should choose to have a caucus access process. We are going to give you a challenging circumstance to actually operationalize, and then we're going to invite any attorney who might want to seek damages on behalf of any individual who feels they've not had the appropriate access, a miniature cottage industry, an opportunity to bring suit after suit after suit against the parties as a means of enforcing this. I philosophically object to that. I'd give the DAs or I'd give the Attorney General or someone else the authority to, in fact, enforce. I don't think giving people with a craven, and I use the word craven in considered form, a pecuniary desire, a financial interest in pursuing this, the ability to, in fact, impede our election process. The reality is the election should be held and managed and controlled by the parties with the support and guidance of the government. It shouldn't be left off to the trial attorneys of Colorado to decide how much disturbance they can create in the electoral process, as would be operationalized, and that would be operationalized flawlessly and with complete effect by this bill, as opposed to the elements that we would be seeking to provide to the candidates, which will be fraught with peril and difficulty. So private right of action in this bill on page 4, lines 13 through 18 is cause enough to reject the bill if that is not stricken, in my opinion. And it refers, just for those that really want to dig into the weeds, it refers to the statutes 24-34-802. When you dig into 24-34-802, you'll find 2 sub A, an individual with a disability is defined in section 301 of this section, who is subject to a violation of subject 1 of this section or other sections based on the individual's disability, may bring a civil suit in court, et cetera. And so, clear as day, you've got your private right of action, cause enough to reject the bill. But the bigger reason that I stand in opposition is not because the goal that we would seek, and that is full access for all members of our society. We stand in solidarity on that, but we just have to do it in a way that's operationalizable, because we right now are struggling under the weight of other access requirements that were passed into law, and they were passed into law and have been acknowledged by the staff of the General Assembly. And I'm just going to talk about the General Assembly, not the other state departments of government, not the school districts of Colorado, not the counties of Colorado. None of them are able to operationalize the access requirements that we wrote into law just a few years ago. And we sit on the precipice of the invitation to lawsuits against us as a body, against us as a state, because we're failing to be able to operationalize something that is intended well, but not capable of being executed upon, putting it into statute, and calling down upon our heads the problems of lawsuits, the expenses of lawsuits. And we're seeing that elsewhere in other access requirements that have been written into law, not because the goal is wrong. The goal is right, but we have to come up with plans and methods of actually being able to provide the access that we are wanting. And this bill will not, in fact, give us that ability. And this falls again, once again, under this theme that I have come back to in the well many times: reality catching up with ideology, reality catching up with aspirational ideas. We've got to, in fact, be able to actually deliver on what we say we want. We can't write into the law books of Colorado an extra 2 hours of daylight every day of the year and expect it to happen. You got to check in with the sun first if you want to have an extra 2 hours of daylight. And that's an extreme metaphor, but it calls out exactly the challenge and the problem with this bill. It's a good, desired outcome, but an impossibility to execute within the context of the framework that has been created by the law. So I urge your opposition to House Bill 1067, not because the goal isn't good. The goal is absolutely something we must stand in solidarity with, but because it is not a fully executable format. I did not have the opportunity to hear the testimony in committee. I'm curious if the Democrat Party showed up and said, here's how we would operationalize this, or the Republican Party showed up and said, here's how we would operationalize this, because the reality is the individuals I've spoken with say it cannot be operationalized. I urge your objection and no vote on 1067.
Senator Danielson.
Thank you, Madam Chair. I kind of want to bring this back again to representation and the community that we're talking about, because elections do matter. Clearly, we have a disconnect from the ability for people to get elected, and we need to do away with that barrier, right? This chamber would benefit greatly by having someone in service who had a disability. I think that any time that we have identified a problem within a particular community, and I'll mention a community of which I am not a part, but am committed to doing right by, we have to listen to them. So the disability rights community has come forward and said, we have identified a solution to a problem. The problem is a barrier to ballot access for people with disabilities. The people who are experts on this issue and a member of the disability community have come to us to say, we're urging your vote on this measure because we know that this will help break down barriers for people with disabilities so that they are more likely to be able to serve. And I, for one, am in favor of breaking down barriers for people with disabilities to serve. Look at the chamber in which we stand today. Even the Senate itself is not accessible for people using wheelchairs or other mobility devices. The Senate itself. And the House wasn't until there was a member who was a wheelchair user. Just a couple of years ago. It's 2024, folks. Elections matter, representation matters. We as a Senate would do better. We would be a better body ourselves if we included more members of the disability community in our ranks. They have identified this as a solution to the problem. I stand firmly in support and firmly with that community to vote yes on this bill, and I urge your support too.
Senator Winter.
Thank you, Madam Chair. We are not asking for unreasonable accommodations, and accessibility and access to the ballot is essential for democracy. This is a vote about protecting democracy, and when we are making the ballot accessible to those with disability, we are actually making it more accessible to everyone that wants to vote, to everyone that wants to participate in democracy, and to everyone that wants to run. And our answer should always be yes on who gets access to democracy and how easy is it. And this is a vote about making it easier. It's not unreasonable. We are not asking for unreasonable accommodations, and I encourage a yes vote.
Senator Gardner.
Thank you, Madam Chair. Well, let me be clear about this one more time. I share the goals of the senator from Westminster. I share the goals of the House prime sponsor. We need to make the electoral process as accessible, as fully accessible as possible within the grounds of reasonable, when lawyers make lots of money on the word reasonable. But we need to do that. As a society, we are doing better at that today than we were 30 years ago. But this bill is not there. It raises more problems than it solves. Now, I appreciated the comments and considerations raised by the senator from Woodland Park, because it begins to do what we ought to be doing with this bill, and that is consider its implementation and what will that look like. And who are we asking to implement it? So, political parties with no public funding, that's appropriate in my view, but political parties with no public funding, operating largely with volunteers, on one day or night every 2 years, have to organize this massive effort in large counties, massive effort to run caucuses. And then they have to turn around with no public funding and largely with volunteers, with the exception of maybe some larger counties who may have some paid staff. Underpaid staff probably is more accurate. Have to mount this large effort for a very large meeting in large counties of 400, 500, 600 people. And this bill says you're going to do certain things to allow for participation of those with disabilities. Okay. It is part of the electoral process in Colorado. And I have to say, I alluded to this in my earlier remarks, a major mistake in the political development of this country was, in my mind, the progressive movement at the turn of, not the current one, but the one at the turn of the 19th and 20th century that began to involve parties with the state meaning government, and state with the parties, which prior to that were wholly private organizations, wholly private organizations. Parties weren't mentioned in statute in 1875, 1880. I venture, you may prove me wrong by going through the law of some of the 48 states that existed. Well, we didn't even have 48 then, but you might go through and find. But nevertheless, here we are, and parties have become, in some ways, intertwined with the state, meaning the government, in selecting candidates for the ballot, which means that the state has the authority, responsibility to dictate how some of these things happen. And that's what this bill is. Now, given the logistics and the administration of that, it ought to be workable, because if it's not, you will just expose parties to legal liabilities. And it's not just my party. I mean, if you're sitting over there and you just go, this will be cool, those other guys will get sued and they'll sue each other and all. It'll happen over here. Now, if you look at the bill, page 4 of the re-engrossed version, a political party may require that a person request to participate in a precinct caucus or a party assembly with the use of a video conference platform or an alternative to a video conference platform as provided in subsection 2C, not more than 30 days in advance of the precinct caucus or party assembly. I think that provision is unconstitutional. Why do I think it's unconstitutional? Because I think, as I talked about earlier, I think it imposes upon a person with a disability who wishes to participate an unreasonable standard for their participation. You will have to decide you want to participate 30 days in advance. You know, I'm highly involved in the political process, and 30 days ago I was trying to remember what night is caucus, what day is that? And we're going to say, well, if you want to participate in caucus and you have a disability and you want to participate remotely, you're going to need to tell the party 30 days in advance. Now, it doesn't say the party has to set the period at 30 days, but you know, if I were them in the exercise of their discretion, I'd put it out as far as I could because there's a lot of logistics around this. There's already an acknowledgement in this bill that in rural areas, somebody might be holding a caucus where there isn't Wi-Fi. So then we have to have a phone. And the phone, but the alternative means of participation, that means probably cell phone, because you hold these things in a school and you can't get to the phone, the landline. The alternative means of participation used by a political party in accordance with this subsection 2 must be accessible to persons with disabilities. I don't know enough about my cell phone to know whether it is or isn't. I suppose it might be in some ways, but when you start to do it for a group meeting, I think it gets really, really tough. But my friends over here make arguments that I think sound, for voting for this bill, that I think sound very aspirational. We need to do this. We need to do this. We got to do this. I agree with that. I agree with that philosophically. I agree with that aspirationally. But legislatively, we got to figure out what our aspirations are. As the minority leader said, you know, I aspire to having more daylight. I think more daylight would be a good thing. I can pass a law, but unless the sun cooperates with me, it ain't going to happen. And that's an extreme example, but it makes the point. You can aspire to a lot of things, but can it work? Now here's the problem. Have I ever voted for aspirational legislation? I have. A lot of bills come through my radar screen in 16 sessions. Do the math. It's staggering. But this is not simply aspirational without consequence. This bill says the failure of any political party to make a reasonable effort to comply. All right, well, lawyers, remember I said a moment ago, lawyers, some of them simple country lawyers and some of them on 17th Street, make a lot of money filing suits over what was reasonable and what was unreasonable. A reasonable effort. And somebody in hindsight could probably say, well, didn't you think about doing this? Didn't you think about doing that? It's a basis, it's discrimination on the basis of disability in violation of Section 2434-802. What's the significance of that? That's statutory damages with attorneys' fees and costs. And any action taken pursuant to this section does not limit or preclude a person from securing or recovering any other available remedy under the Americans with Disabilities Act. This is not just aspirational, it's penal. It will set up the ability to have damages. Now, because this is political parties, I'm going to tell you something else that's going to happen. It's going to happen because it happens in campaign finance. You're going to start having people filing these things just to gotcha because they don't like the current party chair, or they lost their race for party chair and they don't like whatever, and they don't think that the person's doing it is, gotcha, pay me $3,000 per violation plus attorney's fees and costs. Oh, that won't happen. Of course it will happen. And by the way, you say, well, it will only be a few precinct caucuses that will be asked to do this. Well, first of all, I got a problem, and I'll tell you there's a constitutional problem with this 30-day thing. I understand why the parties wanted that, but I think it's a problem with that. It's an unreasonable restriction. But here's how you deal with this if you're advocating for those with disabilities, and there are several organizations in our state who advocate for those with disabilities. They do fabulous work and make a huge difference in this building. What would I do if I were them? Well, whatever the party said was its time frame. And by the way, those organizations are any person. And if this is a more limited definition of person than usual, then one of their people, actual humans, can file a request to both state parties for transmission to all of their county parties that every caucus in the state enable video participation. If I were them, I'd do that, because they will inevitably hear that somebody said, well, I wanted to participate in my precinct caucus, but I didn't realize when it was even until I realized, oh yeah, it's an even-numbered year, and it's happening 2 weeks from now, and I'd like to participate remotely. And they told me, oh, I had to make a request 30 days in advance, and so now the time's passed. So what will those disability advocacy organizations do if I were them? You taking notes back there in the lobby? I would file a request on behalf of my members and the constituencies that I serve that both parties who hold caucuses, the major parties, each and every one of them, make every caucus available. You may want to put my party out of business. Maybe it'll go out of business anyway, I don't know. But do you want to put your own party out of business? Do you want to put your own party out of business? You ought to ask yourself that. Again, let me conclude this round saying one more time, I support the goals of the bill sponsors. I have the same aspirations as they, but as an experienced legislator and attorney and former county party chair and counsel, the problems that will be caused by this bill to the political process within the state will cause much, much more harm than good that we will do, because the bill itself is ill-considered. Ill-considered. I think it can be made to work. I think we can have a legitimate conversation, but that is not this conversation today.
Senator Van Winkle.
Thank you, Madam Chair. And I commend the remarks by my colleague on Judiciary Committee that looks not just at the title of the bill and the well-meaning nature of the bill, but the penal nature of the bill, the penalties that will come from the bill. The senator from Jefferson County, and from Wheat Ridge, was discussing how the bill is for a specific community, but in fact, and it actually looks like that. When you looked at the title of the bill, it is for concerning ballot access for candidates with disabilities, and then you get into the legislative declaration, which doesn't go into statute, but it declares the purpose behind it, and all of that is very well-meaning concerning in referencing the Americans with Disabilities Act of years past on the federal level. But then when the actual text of the bill starts, it actually has nothing to do. It is a blanket over all caucuses, over all people. And so that brings us to questions over things like that were raised, that there are standards in this bill that will be forcing upon a precinct caucus meeting in, say, Holyoke or Ray, Colorado, or maybe a church down in Campo, Colorado, if you've ever been to a church building there. We're passing the requirements on the precinct caucuses that'll be held this week there. And of course, it won't be these, it'll be the following ones because the bill hasn't passed yet. But we're passing those requirements on them, and we ourselves in the Senate have chosen not to implement the Zoom option for voting here. And probably for very well-meaning reasons. It's something that the House of Representatives has chosen to keep the Zoom voting option available for committee and floor work, but is not something that we in the Senate chose to continue at once the COVID crisis had far past the state of Colorado. But again, it's something we're passing upon the people of Colorado and those small communities in Colorado and the big communities that we ourselves are not even going to allow for ourselves. Now, it is a very rare thing that a member of the House of Representatives who's a sponsor to the bill would come here to the Senate to lobby for the bill during the debate. But in a sense, I'm glad perhaps that he is here because we do have some serious questions about the bill that have not been answered. Specifically, well, I guess we can go back to the amendment that passed earlier this morning, which was offered by the senator from Colorado Springs and the bill sponsor in conjunction. And what that did is it adds a third section of the bill that was not there previously for the designation of a party candidates by petition, and it extends to the first business day in January when petition signatures can gather. Now, that sounds frankly terrible to me, but it's a good way for some people to make a living, and it's a good way for candidates to access the ballot if they so were to choose that method, and if they don't want to face their local Republican or Democrat or Libertarian Party and go through the party process. If they want to avoid that party process, they can petition on. And what this does is it takes it from the third Tuesday in January to the first, potentially January 1st, actually, the first it would be January 2nd, potentially, because the first is a holiday, so it would be potentially January 2nd petitions would gather, and then it keeps the same end date in mind, so it just extends it by those further weeks. And the bill itself, this is a contradiction with page 3 of the engrossed version of the bill that says, quote, and I'm reading from the bill itself, the petition process by which candidates may access the ballot is not a means of ballot access that is accessible to a person with disabilities. And now there's a new section 3 that contradicts that statement and adds which I'm not even sure how it really fits with the rest of the bill, because the rest of the bill is dealing with Zoom, the ability to access Zoom for caucuses and assemblies. Then this new section just simply extends the petition process, contradicting the bill itself. So we don't have an answer to that. Then the paragraph that follows after, we also, the good senator from Teller County raised the question about the section immediately after that, where it says, quote, reading from the bill text itself, any person may request, any person must be able to participate in a precinct caucus or a party assembly with the use of video conferencing platform. Now, it didn't occur to me until the good senator from Tulare County raised the point, but any person right now is not eligible to be voting in a precinct caucus. We have rules for that. Any person's not eligible to be voting at a party assembly. We have rules for that. So I think we need clarification on exactly what that means by any person must be able to participate. Does that mean a person that is not registered to vote in that district or even a member of that party may be able to, must be able to participate, quoting the bill once again? That is, again, a part of the bill that will likely be taken to courts. It is a section of the bill that, just by its clear reading to me, any person must be able to participate in a precinct caucus, seems to set aside all rules and regulations pertaining to participation in a precinct caucus. Right now, you must be, if you want to come to the Republican Douglas County precinct caucuses on Thursday night, everyone is, of course, welcome to attend, but if you want to be an active participant who is voting, you need to be a Republican and you need to be a citizen of Douglas County. If you want to go to the Democrat precinct caucuses in Douglas County, you need to be a Democrat and a registered voter in Douglas County, and so on and so forth. So you need to go right now, but the bill itself says, and we never got an answer to this, any person must be able to participate. I was hoping we could get an answer to that. Mr. Majority Leader, I may ask that the bill be laid over so that we can get answers to all these questions. There is, of course, also the unconstitutional aspects that were raised by my fellow member of the Judiciary Committee that I don't need to rehash, but for specifically the reason of figuring out how the amendment that passed this morning works with the rest of the bill in the language that it strikes, and then that, I would, for any of those reasons, I would recommend a no vote, and I would prefer more time to be able to review this because it did pass the House, I believe, almost without any debate whatsoever. I'm not sure the members of the lower chamber, how many of them managed to actually read the bill, because once again, these aren't things that we require of ourselves. It opens, it's not for a specific community, it's for all of Colorado and all members of Colorado. And even that any person language, any person must be able to participate. There's not even, you think it would be any eligible voter or any U.S. citizen. There has to be something that goes in there. And of course, changing the petition process to further degrade the caucus in official, just further injuring the caucus process, further injuring the party process of holding assemblies and precinct people and people running for delegates, the very grassroots foundation that our state so long depended upon for its political foundations is again being spit upon largely by further empowering the petition process to be a much easier, a much simpler process that simply avoids the grassroots. And I appreciate answers to these questions. Thank you, Madam Chair.
Thank you. Is there any further discussion? President Fenberg.
Thank you, Madam Chair. I just want to make a couple of quick comments. We're having some conversations about the bill and the amendments throughout the process and where the bill stands right now. For the record, I support this bill. I support what it's doing. I'm going to vote yes on this bill. Yeah, I know. But I just wanted to make sure we're talking a little bit about not just the intent of the bill, but how the bill is currently drafted. And I understand after lots of negotiations, conversations with different stakeholders, you end up amending it, and then the end product, sometimes without the context, can read a little funny. But the conversation that we were having this is about concerning ballot access for candidates with disabilities. My concern, my worry, is that this also is about access for participants, which I think is great. I would support a bill that said all caucuses and assemblies need to be accessible, and accessible means that it has to have a virtual option. It's not what the title says, but I do support that policy for candidates as well as participants. The thing that I was most confused about, though, and we've been talking through, is the fact that this bill would create a private right of action, I think, for someone without a disability, but under the Anti-Discrimination Act, which I think it's totally fine for people to bring things to folks' attention, to demand change, to maybe pursue legal action to get an institution to be more accessible if they feel like they are violating the law. But I think it's odd to say that someone can have a private right of action as an individual as if they have a disability, even if they don't have a disability. And so it does create a little confusion for me. I think it's probably fixable. I had an amendment, but I think maybe it narrows the bill too much for the sponsors, and I appreciate and respect that. But I just wanted to identify it, that it is a little confusing. And it's not about the intent or what it's trying to do. It's that any violation of this bill would be considered discrimination, even if the person isn't in a protected class, which I think does create a strange precedent for anybody to say they've been discriminated against, even if there isn't a legal justification for how they could have been discriminated against. That's my concern. That's the thing that we've been talking about. And as the good senator from El Paso County would say, I hope you all vote.
Senator Gardner.
Thank you, Madam Chair. Well, I was done, and then the president came and spoke at the well, and it calls for another 30 or 40 minutes of response, but I won't do that. I have opined from time to time that our president has a fine legal mind, not having yet attended law school. And he did a very good job of identifying confusion in the bill as to who has a right of action. This is a lawyer's dream. It's a lawyer's dream. Confusion in bills is really good for lawyers. It's not good for citizens. It's not good for the functioning of government, but it's really good for lawyers, particularly when there's attorney's fees and cost. That is my point about this bill. I share the goals and the aspirations, and I think we probably get there. We'd have to have a very serious conversation about the role of caucus and assembly in our electoral process while doing that, I think. But I'm going to be a no. I'm not a no because I oppose accommodations for those with disabilities or doing everything that we reasonably can to promote the participation of all citizens, including and especially citizens with disabilities. But we can't just wish things and put them on the page and put them in the red books back there. They have larger implications, and so I will be a no, and I urge a no on those grounds and on that basis. Thank you, Madam Chair.
Senator Winter.
Thank you, ma'am. Thank you, Madam Chair. When we lift up the rights and access of those with disabilities, we are lifting up the rights and access to everyone. And lifting up the rights and access to democracy is incredibly important. What we are asking is completely reasonable, and I encourage a yes vote.
Is there any further discussion? Seeing none, the motion before the body is the adoption of HB 1067. All those in favor say aye. Those opposed, no. The ayes have it, and the bill is adopted. Majority Leader Rodriguez.
Thank you, Madam Chair. I move the committee rise and report.
The motion before the committee is to rise and report. All those in favor say aye. Those opposed, no. The ayes have it. The committee will rise and report.
Senate will come to order. Senator Marchman.
Thank you, Mr. President. The committee has met and had a bill under consideration. Will the clerk please read the report?
March 6, 2024. Mr. President, your committee of the whole begs leave to report it has had under consideration the following attached bills, being the second reading thereof, and makes the following recommendations thereon. House Bill 1067 is amended, passed on second reading in order to rise and placed on the calendar for third reading and final passage. Senate Bill 94, laid over until March 7, 2024, and retaining its place on the calendar.
Senator Marchman.
Thank you, Mr. President. I move for adoption of the report.
The motion is the adoption of the Committee of the Whole report. Are there any no votes? Senators Van Winkle, Baisley, Pelton R. With a vote of 31 ayes, 3 noes, 0 absent, 1 excused, the Committee of the Whole report is adopted. House Bill 1067 is amended, passed on second reading in order to revise and place on the calendar for third reading and final passage. Senate Bill 94 laid over until March 7th and retaining its place on the calendar. Consideration of resolutions. Will the clerk please read the title to House Joint Resolution 1019?
House Joint Resolution 1019 by Representative Garcia and Senator Kirkmeyer concerning the declaration of February 29th, 2024 as Rare Disease Day.
Senator Kirkmeyer.
Thank you, Mr. President. I move House Joint Resolution 241019.
To the resolution.
Thank you, Mr. President. May I have it read at length, please?
Will the clerk please read House Joint Resolution 1019 at length?
House Joint Resolution 1019 by Representative Garcia and Senator Kirkmeyer concerning the declaration of February 29th, 2024 as Rare Disease Day. Whereas Coloradans with rare diseases and their families, friends, and caretakers know the challenges they face every day, such as finding knowledgeable providers, obtaining appropriate treatments, and paying and traveling for care, and the many other ways in which life can be extra challenging because of a rare disease. And whereas 1 in 10 people and more than 500,000 Coloradans live with a rare disease, and whereas according to the National Institutes of Health, there are more than 30 million Americans living with the rare disease today, and whereas an estimated 15 million children in the United States have a rare disease, and sadly, 30% will not live to see their 5th birthday, and whereas there are more than 10,000 rare diseases defined as medical conditions affecting fewer than 200,000 Americans, and most of these conditions may affect only a few hundred individuals, and whereas these rare diseases are often lifelong and many are terminal, and whereas most rare diseases are genetic or have a genetic component, no individual or family is immune from a rare disease. And whereas direct medical costs for people with rare diseases are 3 to 5 times higher than those for non-rare diseases, yet, yearly the costs amount to an estimated $400 billion. And whereas fewer than 5% of the known 10,000 rare diseases have an FDA-approved treatment, and whereas in 1983 the National Organization for Rare Disorders pioneered the passage of the Federal Orphan Drug Act, the world's first law incentivizing drug development for rare diseases by offering market exclusivity and tax credits. And whereas the zebra is the official mascot for rare disease patients because historically, medical professionals were taught that when they hear hoofbeats, they should not expect to see a zebra, but should look for the more common answer, a horse. And whereas today we know that 1 in 10 Americans is like a zebra living with a rare condition, it is not always obvious to recognize or diagnose a person with a rare disease, and as a result, this can cause a delay in care and often negatively impact a person's quality of life or life expectancy. And whereas this Rare Disease Day, special events and activities are planned for February 29th, individuals and families affected by rare diseases will be sharing their stories on social media, radio, and TV, in newspaper interviews, and at community events. And whereas we see our constituents with these conditions and acknowledge the need for better understanding, the need for access to care, and the financial impact on families. And whereas we also see that these families, despite the challenges, live their lives with optimism, hope for the future, courage, kindness to others, and most of all, acceptance that this is, through no fault of their own, the life they have been granted. Now therefore be it resolved by the House of Representatives of the 74th General Assembly of the State of Colorado, the Senate concurring herein, that we, the members of the Colorado General Assembly, 1, declare February 29th, 2024, Rare Disease Day in Colorado to help raise awareness of rare diseases within Colorado. 2, show our stripes in solidarity with our community of individual zebras living with the rare disease. 3, recognize and support all of these individuals on this Rare Disease Day in 2024 and every day. 4, salute you for all that it means to live with the rare disease and the humanity that you show in so doing. And 5, on Leap Day 2024, the rarest of days and the day on which around the country we recognize Rare Disease Day, take a moment to appreciate the more than 500,000 Coloradans and the more than 30 million Americans who live with the rare disease today.
Senator Kirkmeyer.
Thank you, Mr. President. And members, feel free to be seated. I'm just going to say a few words here. I'm very honored to have been asked by Representative Garcia to carry this resolution on the Senate floor. I have a cousin who has cystic fibrosis. There's only about 500 people in Colorado that have cystic fibrosis. But I also found out when my daughter was pregnant for the first time that she has the genetic gene. She carries the cystic fibrosis gene. So this kind of hits home for me, and I'm sure that most of you have family members or friends who live with a rare disease. And it's important that we do recognize that there are several Coloradoans who have these diseases, as already stated in the resolution, and it's important that we recognize their day on their day. Unfortunately, we weren't able to do it on February 29th, which is one of the rarest days because it was Leap Day 2024. And it's a day around the country that we do recognize Rare Disease Day. And so hopefully you'll join with me today and take a moment to appreciate that there are more than 500,000 Coloradoans and more than 30 million Americans who live with a rare disease today and every day and deal with those challenges. So with that, I ask for your concurrence and your aye vote on House Joint Resolution 24-1019.
The motion is the adoption of House Joint Resolution 1019. Are there any no votes? With a vote of 34 ayes, 0 noes, 0 absent, 1 excused, House Joint Resolution 1019 is passed. Co-sponsors. Senator Kirkmeyer.
Thank you, Mr. President. I ask for the current roll call to be added as co-sponsors.
Seeing no objection, the current roll call will be added as co-sponsors on House Joint Resolution 1019.
Thank you.
Will the clerk please read the title to Senate Joint Resolution 13?
Senate Joint Resolution 13 by Senator Danielson and Representatives Ortiz and Soper concerning honoring disability rights in Colorado.
Senator Danielson.
Thank you, Mr. President. I move SJR 24-013 and ask that it be read at length.
Will the clerk please read Senate Joint Resolution 13 at length?
Senate Joint Resolution 13 by Senator Danielson and Representatives Ortiz and Soper concerning honoring disability rights in Colorado. Whereas over 500,000 Coloradans live with one or more disabilities, and whereas there are a broad range of disabilities impacting Coloradans in all counties in Colorado, And whereas many spaces in society remain inaccessible to individuals living with disabilities, now therefore be it resolved by the Senate of the 74th General Assembly of the State of Colorado, the House of Representatives concurring herein, that we, the members of the Colorado General Assembly, 1, celebrate March as Developmental Disabilities Awareness Month. 2, recognize the contributions that individuals with disabilities make to our society. 3, recognize that the Federal Americans with Disabilities Act has been law for over 30 years. And 4, strongly support the rights of individuals with disabilities to full participation and inclusion in Colorado.
Senator Danielson.
Thank you, Mr. President. Thank you so much, colleagues. Please take your seats. And thank you for your attention as we recognize the folks in Colorado who have contributed so much to this state over the years who have disabilities. I just wanted to say that we should also have a sense of pride. You might not be aware of the disability rights movement started right here in Denver, Colorado, in 1978 with the Gang of 19. These are some extraordinary individuals who, and actually I've been privileged enough to meet some of these leaders and get to know their stories, what they've gone through. But just down the street is where all this started, when these folks threw themselves in front of the bus and blocked the intersection at Colfax and Broadway and said, "We will ride. We will ride," because RTD didn't have any buses that accommodated wheelchair users. No lifts, no way for someone to come and ride the bus. They're Americans just like you and me. They're Coloradans just like you and me, but they couldn't get on the bus. And that's where it started, and they were successful. RTD became the first place where they made buses accessible across the country. And from there, that Gang of 19, they stayed and they worked and they fought and they battled and they started ADAPT, which is still around and still exceptionally successful at advocating for the rights of people with disabilities at the state and federal levels all across the country. And I can say that probably, I don't know if any of you have, but I think I might be the only legislator that's ever been on an ADAPT action, except for perhaps Representative Ortiz. It's an incredible thing. My mom started off her career in advocating for the rights of disabilities as a case manager and then went on to run an independent living center. And through that time, I've seen the legislature respond in kind to the needs of the community. Where when the Gang of 19 started, I mean, these people were institutionalized across the board. And they fought. And then the folks who came to the movement afterwards fought so that if you didn't walk or couldn't use your arms, you didn't get stuck in an institution. Now, independent living is the norm, and the state respects that, where people with disabilities live and contribute every single place of our society every single day. We had an interesting debate today about folks who are elected to office, and I renew my commitment with this resolution to do everything I can to see that, yes, hopefully, but before I leave this chamber, I serve with a person with disabilities. I was privileged enough to work with Representative Ortiz before he got elected when I was in the House. Since his election, things have certainly changed a lot here, and it's because it takes one person from the community to come and tell us what we need to do to properly serve it. I want to acknowledge that the Disability Rights Day at the Capitol will be tomorrow. We need to pass this resolution today so that they could hear and vote on it in the House of Representatives tomorrow. And so please, if they come and visit with you, listen to what these advocates and volunteers and community members ask of you, what they say they need you to do to support this community. And I appreciate all of your time and attention today. Mr. President, I just urge an aye vote on Senate Joint Resolution 13. And I did want to briefly, since it is tied to the resolution, acknowledge Representative David Ortiz, who has joined us today and is in the back of the Senate. Representative Ortiz, it has been an honor to serve with you. I've carried bills with you. You and I have worked on legislation. It has been just a pleasure to work with you. Before he was elected, some of you might know, he worked with the United Veterans Committee and was an excellent lobbyist for the veterans community in Colorado, an outstanding individual. And on Disability Rights Advocacy Day, I want to especially acknowledge his contributions. The difference one person has made is really extraordinary. And so please, folks, help me in welcoming Representative David Ortiz. And I hope, Representative Ortiz, that in the coming years, someone who uses a wheelchair will be able to come in the Senate and come down to this podium, go up to the president's podium, and preside over this chamber just like everybody else. Thank you, folks, again. Have a great day, and I urge an aye vote on Senate Joint Resolution 13.
Senator Gardner.
Thank you, Mr. President, and I want to thank the sponsors of SJR 2413 for bringing this resolution to honor Disability Rights Month in Colorado. Many people have forgotten that the Americans with Disabilities Act, which has, as the resolution said, been law for over 30 years, and changed the face of disability rights in Colorado and in our nation. Many people have forgotten that this was a touchstone of the George H.W. Bush administration, which highlights the fact that disability rights is not a partisan issue. It is all of our issue. And we all share the aspiration of ensuring that those with disabilities enjoy the same abilities to participate in our system as other Americans. I have had the privilege in my legislative career to carry a large amount of legislation for people with intellectual and developmental disabilities, and have found that to be an issue that came to me. I didn't find it, it found me, and it found me along with colleagues across the aisle who could stand together and ensure that we're providing services, ensure that we're making reasonable accommodations, and that to do so is what every American should aspire to. So again, I recognize Representative Ortiz for being here today. Thank you. Your service as well. And colleagues, I urge an aye vote. I know you will be. Remember every day, take a moment to remember that it's Disabilities Rights Month here in Colorado, and that we should all recommit ourselves to the aspirations of that. Thank you, Mr. President.
The motion is the adoption of Senate Joint Resolution 13. Are there any no votes? With a vote of 34 ayes, 0 no, 0 absent, 1 excused, Senate Joint Resolution 13 is passed. Co-sponsors, Senator Danielson.
Thank you, Mr. President. If there's no objection, I would hope that we could add today's roll call vote as co-sponsors.
Seeing no objection, the current roll call will be added as a co-sponsor on Senate Joint Resolution 13. Consideration of House amendments to Senate bills. Will the clerk please read the title to Senate Bill 4?
Senate Bill 4 by Senators Pelton, R. Fields, and Representatives Frizzell and Lindstedt concerning the administration of county veteran service offices.
Senator Pelton.
Thank you, Mr. President. I move the Senate concur with the House amendment. There's reason.
That's an interesting decision. Senator Pelton, can you please explain to the chamber what the House did to your bill?
Well, Mr. President, thank you. You know, what they did over there was really a good thing. What they did was make a working group that county commissioners will help advise on this, this bill that, you know, involves county commissioners and the veteran service offices. So with that, I would ask that we concur.
Senator Fields.
Thank you, Mr. President. We move for the readoption of Senate Bill 004.
Senator Fields, just one moment. We need to take a vote on concurrence first. Is there any further discussion on concurring with House amendments to Senate Bill 4? The motion is that the Senate concur with House amendments to Senate Bill 4. Are there any no votes? With a vote of 34 ayes, 0 no, 0 absent, 1 excused, the motion is adopted. Senator Fields. Senator Pelton.
Thank you, Mr. President. I move for the repassage of Senate Bill 004.
Is there any discussion? Seeing none, the motion is the repassage of Senate Bill 4. Are there any no votes? With a vote of 34 ayes, 0 noes, 0 absent, 1 excused, Senate Bill 4 is repassed. Co-sponsors, Senators Bridges, Kirkmeyer, signing of bills.
March 6, 2024, the President has signed Senate Joint Resolution 12.
Committee reports.
March 5, 2024, Committee on Finance, after consideration on the merits, the committee recommends the following: Senate Bill 126 be amended as follows, and is so amended be referred to the Committee on Appropriations with favorable recommendation.
Announcements. Senator Kolker.
Thank you, Mr. President. Today, I'd like to request a moment of personal privilege.
Granted.
Thank you. Today is Mental Health Colorado's Legislative Education and Advocacy Day. We have members, advocates here from Mental Health Colorado sitting over here on the floor this morning, and I'd just like to acknowledge them. And I have a little note here to go over what their theme is for this year. Their theme this year is Care, Not Cuffs. Here are a few things they are focusing on this year. Too often, law enforcement officers are the front line in the supporting people in a mental health or substance use crisis. This has to change. Our jails can no longer be our largest behavior health providers in this state. We advocate to support a system that gets people the treatment they need and deserve to address their health condition. They are here, and I am here with them, supporting bills and policies that would help improve access to care and decrease the reliance on the criminal justice system. Members, if you could please acknowledge the advocates that are here today. If you see them, they'll be here all day or through lunch. Thank you.
Senator Liston.
Thank you, Mr. Chairman. Mr. Chairman, is this microphone on? Yeah. Mr. President, I owe $1 already.
It was the microphone's fault. Sorry.
Thank you. Thank you. Mr. President, I would ask for a moment of personal privilege.
Granted.
Very good. Members, if I can have your attention, please. I think you all know by now that a lot of us here in the chamber are very passionate and aware of the situation that's been going on in the country of Ukraine for the last 2 years or more. And I'm here not only to speak for myself, but to pay a tribute to an organization that has done a yeoman's work and the Lord's work on behalf of the embattled people of Ukraine. We see it every single day in the newspapers and on the news, the open aggression by the country of Russia, by the good people of Ukraine. And I might add, I have no Ukrainian relatives, but in the 21st century, it is unbelievable what has happened to a peace-loving, good people of the country of Ukraine. We all know of the devastation that has occurred and occurs each and every day where people are needlessly slaughtered by the aggressive Russians. So with that in mind, Mr. President and members, I would like to read a tribute and give a tribute. Is that possible, Mr. President?
Certainly. Please proceed.
So I'll read it. Members, the Senate of the Colorado Legislature convened in the second regular session of the 74th General Assembly hereby recognizes Ukraine Power. Saturday, February 24th, marked the 2-year anniversary of Russia's unprovoked invasion of Ukraine. For 2 long years, Russia has launched thousands of attacks against the people of Ukraine, destroying roads, homes, schools, and hospitals. Russia has caused over $1.6 billion in damage and left over 10,000 civilians dead and some 20,000 injured. More than 1,000 Ukraine towns have been left without electricity, running water, and heat as winter has arrived throughout Ukraine. Ukraine Power, a Colorado Springs 501c3, has worked hard to deliver over $110,000 worth of supplies to the embattled people of Ukraine. They're most proud of providing Nevsky, a damaged town in the front lines, with stoves to cook, with generators to heat their homes, and other items that will keep the people of Ukraine warm in their homes without electricity. The Colorado Senate recognizes and commends Ukraine Power for their continued efforts to help the Ukrainian people and for their advocacy on behalf of Colorado's sizable Ukrainian population. On the request of Senator Larry Liston, given this 6th day of March 2024 in the state capital of Denver, Colorado, signed by the Senate President Stephen Finberg. And with that in mind, members, I'm very pleased to have a number of guests here representing not only Ukraine Power, but the people of Ukraine. And if possible, Mr. President, may I introduce our guests?
Yes.
Thank you. Members, if you'll join me here after I've introduced them all. First of all, Amy Hill, if you'll stand. She is with Ukraine Power. Colonel Ed Ward, United States Air Force retired. He's a board member of Ukraine Power. And the founder, Miss Yana Malik, she's the founder of Ukraine Power and a citizen of Ukraine who has come over here with her 2 daughters and her husband. She is from the war zone in eastern Ukraine and has many family members in Ukraine as well. Miss Anne-Marie Pasitio, who is also with Ukraine Power, and Yuri Hristak, who is a citizen of Ukraine and a student at Colorado College, and he studies political science. And last but not least, Kristen Murdoch, who is a photographer with the Gazette in Colorado Springs. Would you join me in recognizing and welcoming these good, brave people? Members, please sit down. Thank you. I have placed on your desk, or the good sergeants have placed on your desk, and a number of you wear these throughout the year. These are ribbons in support of the good people in Ukraine. I hope you will join me, not only wearing it today, but each and every day that you can, that you remember to honor the bravery of the citizens of what's going on in Ukraine and what Ukraine Power is doing. It's unbelievable. You know, we think we have a tough winter when we have to, here over the month of February, where we've had some unusual snows and it's dipped down to 15 or 20 degrees. In the country of Ukraine, it's commonplace during December, January, February that it's below 0 day in and day out. And imagine what it's like if you have no heat and no electricity, and worse yet, that the apartment building or your home has been devastated by a rocket that was fired, missile that was fired from 200 or 300 miles away, that literally blows up your home and kills people around you day in and day out. That is what the citizens of Ukraine are faced with each and every day. So I hope that you will keep them in your thoughts and your prayers as they continue to go through their third winter of devastation. And with that, thank you, Mr. President. Thank you, members, for honoring Ukraine Power and the people of Ukraine. Thank you very much.
Senator Hansen.
Thank you, Mr. President, and I request a moment of personal privilege.
Granted.
I'd like to join the good senator from Colorado Springs in this important tribute. And I've got 3 quick ideas that I wanted to share in support of this important topic. First of all, we know exactly who the president of Russia is. We know exactly who he is, and he just proved it again by enabling the murder of Navalny in a frozen prison in Siberia. Just proved it again. We cannot be silent about that. We should not be silent about that. And U.S. politicians who apologize for Putin should not be in a position of power. Number 2, democracy in Europe is on the line here. We know that. That's why the United States responded quickly. It's why the European allies in NATO responded quickly. It's why Sweden and Finland are now in NATO. The EU recently came forward with another $60 billion in aid, while the U.S. debates additional aid in Washington. Democracy is on the line in Europe. The European allies are stepping up. Why are we waiting in the United States? The support is urgent. The battlefield proved it again this week. Russian advances enabled by delayed U.S. aid. This is a bipartisan tribute. I am thankful for that. This is largely a bipartisan issue, but we have a partisan problem with continued aid in Washington right now. There is a small faction in the U.S. Congress that's stopping it. There is a presidential nominee that is doing everything he can to stop it. How many times do we need to make the mistake that somehow isolationism is going to work? It never has. It never has. Just in the 20th century, we had multiple examples of it not working. Why repeat that mistake in the 21st? Members, I strongly support this tribute. We know exactly who we're up against. It is time for us to do our part.
Senator Liston.
Thank you, Mr. President. And may I ask for a minute or two recess so that our members may greet our guests from Ukraine and Ukraine Power. Would that be possible?
Yes, members, if there are further announcements, let's do those quickly, and then we will, because I think that is all that we have left. So if you have announcements, please come to the well, make those announcements, and then we will recess to greet our guests that are visiting. Senator Gardner.
Thank you, Mr. President. Actually, I request to be excused tomorrow, March 7th. I've spoken to the minority leader, who's somewhat sad by my absence, the majority leader who nearly cheered, and I assume, Mr. President, who will be grateful that I am absent, that I request that excusal.
Senator Gardner will be excused for the rest of the month of March. Senator Michaelson-Jeannet.
Thank you, Mr. President. Good morning. The Colorado Women's Chamber of Commerce is hosting their day at the Capitol tomorrow, Thursday, March 7th, and will be serving breakfast outside of the old Supreme Court chambers from 8 to 9. Please take time to go say hi to women in business leaders throughout Colorado. They're lots of fun, and I'll be there. I hope to see you.
Senator Buckner.
Thank you, Mr. President. Senate Education Committee will meet this afternoon at 1:30, room 357. We're hearing Senate Bill 162.
Senator Gonzalez.
Thank you, Mr. President. Colleagues, the Senate Judiciary Committee will be meeting at 1:30 p.m. in the Old Supreme Court. We will be hearing the bills and appointments on the calendar as printed.
Senator Bridges.
Thank you, Mr. President. Senate Appropriations will meet this Friday, for real, for real. We will see you this Friday, 8:30 a.m. Look forward to it, everybody.
Senator Winter.
Thank you, Mr. President. Senate Transportation and Energy will be meeting today at 1:30, and we will be hearing Senate Bill 100. Look forward to seeing you there.
Senator Roberts.
Thank you, Mr. President. Agriculture and Natural Resources, we're meeting upon adjournment, let's say 11:20. So if you get up there fairly quickly, 11:20, we have Senate Bill 137 and 161.
Senator Fields.
Good morning, Mr. President, colleagues. Members of the Senate Health and Human Services Committee, we will be meeting at 11:20 upon adjournment. We have 2 bills for consideration, and we are adding Senate Bill 142 to the calendar. Thank you.
Senator Van Winkle.
Thank you, Mr. President. My apologies to the chair of the Health and Human Services Committee. I typically don't sit on this committee. It's my first time today. What? We're adding a bill that's not. Oh, 142 is being added to the printed calendar. Okay. I just haven't seen that happen. I'm used to following the calendar. Thank you.
Welcome to the Health and Human Services Committee, Senator Van Winkle. Buckle up. The Senate will stand in a brief recess to allow us to greet our guests who are visiting the Senate chambers, and we will come back momentarily to clarify what is happening in Health Committee and also just simply to adjourn. Senate will stand in a brief recess.